In this video, I'm going to be talking about the 3 biggest injustices in the criminal justice system and what you and your attorney can do about them. My name is Veronica. I'm a criminal defense attorney here in California, and I help people put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be going over the 3 biggest injustices in the criminal justice system and what you and your attorney can do about them. And some of these are probably things that you haven't thought of before and that your attorney may not want to tell you, but I'm here to give you the truth. Injustice number 1 is the way that the prosecution handles turning over discovery to the defense. Okay, so first of all, discovery in the context of a criminal case refers to basically evidence. So the police reports, but also any surveillance video, body-worn video, witness statements, anything that you as the defendant said, basically all of the evidence in the case. Now, it is the DA, the prosecutor's obligation to turn that over to your defense attorney. But the question is, how quickly are they going to turn it over? And in my experience in California, it is very, very slow. Especially for big cases and especially for serious cases where there's a lot of documentation, they're very slow to turn it over. And by very slow, I mean if you let the prosecutor have his way, it may be a year and a half until you get all of the evidence. And of course, the thing that you want, especially if you're innocent, is to see what they have on you. Right? If they say they have surveillance video and you know you didn't do it, well, let's see the surveillance video. So let's talk about how to handle this. First, your attorney can, at your first court date, look through the police report and see if it mentions any body-worn video or any surveillance video, any witness interviews, any evidence that is mentioned in the police report as existing but hasn't been turned over. Your attorney can then request that from the prosecutor before court actually starts. And then once you're in front of the judge with the court reporter, your attorney can, on the record in front of the judge, say, and I spoke to Mr. Prosecutor, I requested the body-worn video, the surveillance video, and the witness statements that are all mentioned in the police report, and he told me that he would have it to me within the next, 2 weeks. And always try to get a time frame. That's really important. Then the judge is very likely to write that in the file. So then you can use the judge if you need to. If you don't have it at the next court date, use the judge to put some pressure on the prosecutor. Now look, to play devil's advocate, how this works for the prosecution is kind of a pain. Usually all they get is the police report themselves, and they have to request from the police body-worn video, surveillance, any of the other stuff. And so it's kind of an administrative headache. Obviously, if they're not very organized or if they're really busy, it can slip through the cracks. So what I like to do is send them an email saying, hey, we talked about this at court. I requested these documents from you. Now I have proof that I requested it. I have documented my request for this, but also it's a reminder to the prosecutor. And then if I still don't have it before court, time to send another reminder. I mean, this is really just a practical thing. And, it's not my job to be the prosecutor's secretary, but if it's going to help my client, especially if they're in jail and just haven't even seen the evidence yet, then why not do that? If you still haven't seen the evidence, especially if it's a really important piece of evidence, then your attorney should be reminding the prosecutor and should be documenting all of that. Third, look, if you were there, if you were at the scene of whatever happened, whether the police got it right or not, whether you're guilty or innocent, if you were there and you think that there's some other evidence that might exist, it could be a witness, it could be surveillance video that, maybe your attorney doesn't know about because the police didn't mention it in their report. Make sure to tell your attorney. That's really important. Since you were there, you know what evidence might exist. Number 4 is your attorney can sometimes get a private investigator appointed and paid for by the court that works in LA County. It doesn't always work in all counties. Or you can pay for one privately to go and collect some of this information. I've had a police report before that mentioned surveillance video and described it, but the police had only collected one surveillance camera's footage, and the other surveillance camera's footage was equally important. But if I hadn't had a private investigator go out there right away, it could have been lost forever, and it was very helpful to my client and to my case. Private investigators are also great at going to knock on doors. I have one in particular in LA County who's amazing. He will go knock on doors, talk to any witness. He's been threatened before. He doesn't care. He keeps going. That's really important if you have of witnesses who you think are going to be helpful. Get their statements early before too much time passes, and don't count on the police to do investigations. Many times they are much more focused on prosecuting you than they are on investigating what actually occurred. And some prosecutors are going to hate me for saying this, but sometimes the best thing to do is to not give the prosecutor more time. So in criminal cases, you have a right to have a speedy preliminary hearing in felony cases and a speedy trial in all cases. What that means is that there's a set number of days for you to be brought to preliminary hearing or trial. Generally in these cases, the time frame is so short, it gets 10 court days for preliminary hearings, for example, that it's going to be advantageous to you to build your strongest defense to push that date back. So it's not maybe within 10 court days, but it ends up being within 30 or 60 court days or something like that. In general, in order for your attorney to file whatever motions they might want to review everything, to get the private investigator, they're going to need more time. But if you really want to light a fire under the prosecutor's butt, one way to do it is to just set the case for the preliminary hearing or for the trial, depending on the circumstances, within that period of time and refuse to waive any time. Now, you're probably going to want to push that date out later. What will happen if you refuse to push that date out, aka waive time? If you refuse to do that, now your case jumps to the top of the prosecutor's probably very big pile of cases, and so now you are more likely to get your discovery much sooner, and then your attorney can ask for that date to be moved, saying, hey, I just got a bunch of discovery, I need to review it. Now, the reason why I say prosecutors probably are going to hate me is that this is a big administrative headache for them, but may I suggest that before any charges are filed, the police be required to turn over all of the evidence to the prosecutor. So the prosecutor has it right there and can give it to the defense attorney on day one, and then the prosecutors won't have any reason to hate me for using this tactic. Injustice number 2 is bail, and there are many problems with the bail system in my opinion, but one of the biggest problems is that bail is set based on the assumption that you are guilty of whatever you're charged with. And sometimes you have a strong defense, sometimes a jury ends up acquitting you, sometimes the DA ends up dismissing it, but your bail may be set so high that you just can't financially bail out. So what can be done about that? Your attorney can file a motion to reduce bail. Now, in general, if there's enough time before the first court date, I recommend having your attorney write a motion to reduce your bail. To me, whenever there's an opportunity to have something written that the judge can read and look at, and the DA can read and look at that says good things about my client, in addition to me just arguing in front of the judge at court, I want to do that. Now, what's key here is that your attorney has to know the good things about you before your first court date. So if you're in jail and there's not enough time to visit you, then your attorney maybe will talk to your family members, whoever's hiring them, to try to get that information and have it ready. If that's not possible, or if there's not enough time before court, then your attorney can also talk to you before the case is called. And that's really important, so that they know these good things about you, your ties to the community, your financial limitations, everything that the judge is going to want to hear, so that they can argue it in front of the judge. Your attorney should be ready, and you should accept the possibility of getting out or getting a lower bail, but on the condition that you take certain classes, that you wear an ankle monitor, that you wear an alcohol monitor, for example. And even if you're out of custody, it is really important for your attorney to know all of the arguments in favor of keeping your bail set as it is, rather than it being raised. There are certain things that can happen. They're called change of circumstance in your case. Maybe a new charge is filed. Violation of restraining order is a really common one. Violation of restraining order or protective order is super common. And now all of a sudden there's a new charge. And sometimes the judge on their own motion or the prosecutor will ask for your bail to be increased. Your attorney should be ready so that they can make the best possible arguments for you so that you don't end up going into custody. And if you are unable to bond out, then encourage your attorney to move the case along quickly. Now, with private attorneys, sometimes this is a problem where, time is being pushed out for no good reason, but this is a really common problem with the public defenders. The reason why they want to push it out is because they have too many cases at once, and maybe they're waiting for the discovery because they don't want to piss off the DA that they deal with every single day by just setting the case for a preliminary hearing or trial. So it's really important to encourage them to move the case along and tell them how important that is to you. Number 3, and this injustice really kills me, is retrials and re-prosecutions. Okay, so basically how this works is that if you go to trial and the jury can't agree on their guilty, not guilty verdicts, then a mistrial will be declared, meaning that the prosecution can refile charges and you will have to go through the whole thing all over again. This applies even when 11 people voted not guilty and 1 person voted guilty. Now, for serious crimes, they are very likely to retry you. It is possible that the DA's office in certain circumstances could decide, you know what, it's not worth putting in the time, putting in the expense. So what can you do in this situation? There are 2 things that you can do about this. The first one is that your defense attorney can invite the judge to make a motion to dismiss based on the interests of justice. Now, it's kind of a weird technical thing, but your attorney can't make the motion themselves. They have to suggest it to the judge and get the judge to do this. But this is really rare, especially in really serious cases. The judge doesn't necessarily want to just go ahead and dismiss. But let's say that they've already tried you twice. Both times it was very heavily not guilty, only a few guilty. Maybe you could have a chance with the judge. You know, of course, it depends on your judge, and especially in the really serious cases, if it involves an alleged gang member, if it involves murder, they're not going to want to do it. So the other suggestion, the other thing that you can do that is within your control, if the judge says no and will not accept your attorney's invitation to dismiss it, is use it. So use the fact that now the prosecution's witnesses have testified at least once before, probably twice, and probably made statements to the police 3 different times that they've given statements, and now they're going to give statements a 4th time. Imagine telling the same story and getting all the details right 4 different times, and especially if there are any witnesses who are lying. It's going to be very difficult. So your defense attorney's job is going to be, in part, to look for all of the inconsistencies there and point out the serious ones. As a defendant, when you are retried, especially if you're sitting in jail, you've maybe spent a bunch of money on a private criminal defense attorney for trial, you can feel like your case is depleting, like your resources are depleting, your drive to move forward. So what your attorney needs to do is make sure that the same thing happens to the prosecution's case. I hope you found this video helpful. If you do have a criminal case in California, feel free to book a consultation with me down below. You can also find my phone number there.